New York real estate broker license lookup. Let's get started. A real estate transaction in Queens involves a property with a mechanic's lien filed by a contractor for unpaid work. The seller wants to close without paying it off. Under New York legal issues, what risk does the buyer face? Is it A, the lien automatically expires at closing? Or B, the buyer could inherit the lien on the title? Could it be C, the lien only affects the seller? Or lastly D, the title insurance will always cover it? The correct answer is B. Here is why. A mechanic's lien attaches to the real property itself. If not satisfied at closing, the lien remains on title and the buyer takes title subject to the lien. Option B is correct. Option A is incorrect. Liens do not automatically expire at closing. Option C is incorrect. Liens run with the land. Option D is incorrect. Title insurance may exclude known liens or require specific coverage. Next question. A first-time homebuyer in Queens obtains a VA loan for a property purchase. The salesperson explains that this loan allows for no down payment. However, what fee might the buyer still have to pay under New York real estate finance? Is it A, origination fee? Or B, funding fee? Could it be C, appraisal fee? Or lastly D, all of the above? The correct answer is B. Here is why. VA loans require a funding fee, which is a percentage of the loan amount paid to the VA to offset program costs. This fee may be financed into the loan. Option B is correct. Option A, origination fee, may be charged by lenders but is not unique to VA. Option C, appraisal fee, is a third-party cost, not specific to VA. Option D is incorrect because the question asks what fee the buyer might still have to pay, in context of VA's unique requirements. Next question. In Albany, a purchase contract for a home states that the closing must occur on or about June 1st, but the seller delays until June 15th due to personal issues. Is the buyer entitled to cancel under New York contract law? Is it A, yes, if time is of the essence? Or B, no, on or about, allows flexibility? Could it be C, yes, always for delays over 7 days? Or lastly D, no, unless specified in writing? The correct answer is A. Here is why. In New York real estate contracts, time is of the essence must be expressly stated to make deadlines strictly enforceable. Without such language, on or about permits reasonable flexibility. However, once a party demands closing and makes time of the essence, the buyer may cancel if the seller fails to perform. Option A is correct. If time is of the essence, the delay may justify cancellation. Option B is correct generally, but does not address the buyer's right to declare time of the essence. The better answer is A because the question asks if the buyer is entitled to cancel, which requires time to be of the essence. Next question. A licensed real estate broker in Buffalo, New York, employs several salespersons and decides to pay a referral fee to an unlicensed individual who provided a lead that resulted in a successful property sale. The broker believes this is acceptable as long as the fee is not considered a commission split. Under New York Department of State regulations governing real estate licenses, is this action permissible? Is it A, yes, as long as the referral fee is documented in the closing statement? Or B, no, because only licensed individuals can receive compensation for real estate activities? Could it be C, yes, if the unlicensed individual is a family member of the broker? Or lastly D, no, unless the referral fee is less than 1% of the sale price? The correct answer is B. Here is why. New York Real Property Law Article 12A strictly prohibits paying compensation for real estate brokerage activities to unlicensed persons. Referral fees for leads that result in a sale constitute compensation for activities requiring a license. Option B is correct. Option A is incorrect. Documentation does not legalize an unlawful payment. Option C is incorrect. Familial relationship does not exempt the unlicensed individual from licensing requirements. Option D is incorrect. No de minimis exception exists for referral fees to unlicensed persons. Next question. During a transaction in Long Island, the listing agent learns from the seller that the property has a history of minor flooding in the basement during heavy rain, though it has been mitigated with sump pumps. The agent does not disclose this to the prospective buyer because it is not a structural defect. Under New York property disclosure and material fact rules, has the agent met their obligation? Is it A, yes, only major structural defects require disclosure? Or B, no, known material defects affecting value or desirability, including water intrusion history, must be disclosed even if mitigated? Could it be C, disclosure is only required if the buyer asks about flooding? Or lastly D, the Property Condition Disclosure Act exempts agents from liability for seller-provided information? The correct answer is B. Here is why. Water intrusion history is a material fact affecting value and desirability. While New York adheres to caveat emptor for sellers, licensees have an affirmative duty to disclose known material defects and cannot remain silent. Option B is correct. Option A is incorrect. Materiality is not limited to structural defects. Option C is incorrect. Disclosure is required regardless of inquiry. Option D is incorrect. Agents may be liable for non-disclosure of known facts. Next question. In a transaction involving a commercial property in Rochester, New York, the real estate salesperson acts as a buyer's agent and negotiates terms on behalf of the buyer without informing the seller of the agency relationship. The seller later discovers this and claims a breach. What fiduciary duty did the salesperson potentially violate? Is it A, obedience to the buyer's instructions? Or B, disclosure of the agency relationship to all parties? Could it be C, loyalty to the seller's interests? Or lastly D, accounting for all funds? The correct answer is B. Here is why. A licensee has a duty to disclose their agency representation to all parties in a transaction. Failure to disclose that they represent the buyer constitutes a breach of the duty of disclosure and potentially creates an undisclosed dual agency. Option B is correct. Option A is incorrect. Obedience to the buyer does not excuse non-disclosure. Option C is incorrect. The salesperson owed no duty of loyalty to the seller. Option D is incorrect. No funds accounting issue is presented. That's it for today. How many did you score? Let me know in the comments. Please like and subscribe and tell me what topic I should cover next. Bye.